Welcome to my channel. In this video, we will be discussing about legal options and practical next steps for delayed investor payouts by private financial firms. When a reputed private financial firm stops paying the monthly returns it had promised to investors, the issue is no longer merely a matter of inconvenience or delay. It becomes a serious question of contractual breach, possible financial misconduct, and in some cases potential cheating or unlawful deposit taking. The position becomes even more serious where there are written agreements, post-dated checks, repeated assurances of future payment, and then a pattern of stopped checks or dishonored checks after maturity. In such a situation, affected investors should not rely indefinitely on verbal promises. They should begin preserving evidence and move through the available legal, regulatory, and enforcement channels in a disciplined way. Before choosing the right remedy, investors should identify what the firm actually is in regulatory terms. A company may be incorporated or registered in a general sense, but that does not automatically mean it is authorized to mobilize public money in whatever form it chooses. For practical purposes, investors should verify whether the entity is a SEBI-regulated intermediary or scheme, an RBI-regulated NBFC permitted to accept deposits, or an allegedly unregulated deposit taker. RBI maintains public information on NBFCs and specifically identifies NBFCs permitted to accept public deposits, while SEBI provides tools to check the registration status of market intermediaries. RBI's Sachet platform also exists, so members of the public can check whether an entity is registered with a regulator and permitted to accept deposits, and can file complaints if money has been accepted illegally or deposits are not repaid. This distinction matters, because the complaint route depends on the nature of the product and the status of the firm. If the matter falls within the securities market and the entity is SEBI regulated, SEBI's grievance system may be relevant. If the case involves an NBFC deposit default, RBI-recognized remedies become important. If the firm has taken money under an unregulated or misleading scheme, the Banning of Unregulated Deposit Schemes Act, 2019 may come into play. That act prohibits unregulated deposit schemes, prohibits fraudulent default even in regulated deposit schemes, and prohibits false or misleading inducements to make people invest in unregulated deposit schemes. Once payments start failing, investors should stop treating the matter as an ordinary delay and start building a record. In practice, this means preserving the written agreement, payment receipts, account statements, all emails and messages, audio or written promises of extension, copies of post-dated checks, bank return memos, and any brochures or representations that were used to induce the investment. If the firm has changed its story several times, that pattern itself may become relevant. Where multiple investors are affected, a consolidated chronology and document set can be especially useful when approaching a regulator, the police, or the EOW. If the firm issued post-dated checks and those checks were dishonored, check bounce proceedings are often one of the most practical remedies. Section 138 of the Negotiable Instruments Act applies, where a check issued toward a legally enforceable debt or liability is returned unpaid for insufficiency of funds or similar reasons. The statute requires the check to be presented within its period of validity, the payee to issue a written demand notice within 30 days of receiving information of dishonor from the bank, and the drawer then gets 15 days from receipt of that notice to make payment. If payment is still not made, the complaint must ordinarily be filed within 1 month from the date when the cause of action arises. The law also presumes, unless rebutted, that the check was received toward a debt or liability. Where the drawer is a company, company-related liability issues can also arise under the same chapter. Because the limitation periods in check matters are strict, investors should not delay once the bank returns the check unpaid. Even where check proceedings are started, other remedies may still remain open depending on the facts. If the investment or scheme falls within the securities market and the entity is regulated by SEBI, the investor should first raise the grievance with the entity itself and, if unsatisfied, may lodge a complaint through SCORES, SEBI's online grievance redressal system. SEBI states that complaints on SCORES are for grievances against listed companies, registered intermediaries, and market infrastructure institutions, and current SCORES material states that the complaint should be lodged within 1 year from the date of the cause of action. If the default concerns an NBFC deposit, RBI's own investor guidance says the depositor should immediately approach the RBI. RBI further states that such a complainant may also approach the NCLT, the Consumer Forum, file a civil suit, or file a police complaint. RBI also warns that the public should verify whether an NBFC is actually registered and specifically authorized to accept public deposits, and states that making a false claim of being regulated by RBI to mislead the public into placing deposits is illegal and can be reported to the nearest RBI office and the police. If the suspicion is that the firm has illegally mobilized money or defaulted in repayment of deposits outside a proper regulatory structure, the Sachet platform is particularly relevant. RBI says Sachet allows the public to check whether a deposit-taking entity is registered and permitted to accept deposits, and to file and track complaints where money has been illegally accepted or deposits have not been repaid. Investors are often justified in approaching the local police, and in serious cases, the Economic Offenses Wing, when the facts suggest more than a mere business setback or delayed payment. If there is evidence of deceptive inducement from the beginning, diversion of funds, large-scale collection from multiple investors, repeated false assurances, or deliberate stopping of repayments while continuing to solicit money, the matter may warrant criminal investigation. The Banning of Unregulated Deposit Schemes Act specifically addresses fraudulent default in regulated deposit schemes and false or misleading statements used to induce participation in unregulated schemes. Delhi Police describes the EOW as a specialized police unit for large-scale financial and economic frauds with wide ramifications, and UP Police similarly describes EOW as investigating cheating, fraud, and misappropriation, including cases involving private persons or companies where the economic offense has serious ramifications. A police or EOW complaint is therefore not a symbolic step. It may be appropriate where the facts indicate cheating or organized financial misconduct. At the same time, investors should understand that criminal process is not a substitute for recovery proceedings. The practical position is that criminal, check bounce, regulatory, and civil routes may coexist. The Banning of Unregulated Deposit Schemes Act expressly says its provisions are in addition to, and not in derogation of, other laws. A cybercrime complaint is not automatically the correct route in every default case. The official cybercrime portal is meant for cyber offenses and online financial frauds, and Sachet also points users to the National Cybercrime Reporting Portal and Helpline 1930 for cybercrimes, including financial frauds committed online. That means the cyber route is most appropriate, where the fraud involved online misrepresentation, fake apps or websites, digital wallet or bank transfer deception, phishing, account compromise, or similar online conduct. A pure offline repayment default or dishonored check dispute without a genuine cyber element would usually be better pursued first through check proceedings, police or EOW, regulator complaints, or civil recovery. Not every investor problem is solved by a criminal complaint. Where the core problem is non-payment under a written agreement, investors may also need a civil recovery strategy. RBI's guidance on NBFC deposit defaults expressly mentions the NCLT, Consumer Forum, civil suit, and police complaint as possible avenues. In practice, the right forum depends on the legal character of the transaction, the type of entity, the wording of the contract, and whether the claim is best framed as deposit repayment, deficiency in service, contractual recovery, or something else. Publicly exposing the firm on social media may feel attractive, especially where investors believe they are being strung along, but it should not be treated as the main remedy. Under the Bharatiya Nyaya Sanhita, defamation can arise where a person publishes imputations intended to harm reputation, including imputations concerning a company. The same provision also recognizes exceptions for statements that are true and for the public good, complaints made in good faith to lawful authorities, and imputations made in good faith for protection of one's own interests or for the public good. The safer position, therefore, is that investors should prioritize formal legal complaints and, if they speak publicly at all, keep statements factual, restrained, evidence-based, and free from exaggeration or abuse. A rational response is usually sequential and organized. Investors should first gather documents and stop relying on oral assurances. Next, Any dishonored check should be acted upon quickly through a proper legal notice under the Negotiable Instruments Act. In parallel, the firm's regulatory status should be checked through RBI, SEBI, and Sachet. If the facts suggest an NBFC default, an RBI complaint becomes relevant. If the matter concerns a SEBI-regulated product or intermediary, scores should be considered. If the pattern looks like unlawful money mobilization or deliberate cheating, a police or EOW complaint becomes stronger. Where there is an online fraud element, a cybercrime complaint may be added. Alongside all of this, investors should evaluate civil recovery, consumer, or NCLT-type proceedings with a lawyer based on the exact structure of the transaction. In India, investors facing this kind of prolonged default are not without remedies. A stopped or dishonored check can trigger a specific statutory process. A deposit default may justify complaints to RBI and, depending on the facts, civil, consumer, NCLT, police, or EOW action. If the scheme appears unregulated or misleading, Sachet and the Banning of Unregulated Deposit Schemes Act become important. If the misconduct happened through online fraud channels, the cybercrime system may also be relevant. What investors should not do is remain passive while the firm keeps extending timelines without payment. Once there is a clear pattern of default, the prudent course is to move from informal follow-up to evidence-backed legal and regulatory action. This video is general information, not case-specific legal advice. For an actual dispute, the facts, the documents, the status of the firm, and limitation periods need to be examined carefully by an Indian lawyer. If you enjoyed the video, don't forget to like, comment, and share it. Subscribe to my channel for more content on relationships and family, social issues and empowerment, mental health and personal growth, and a variety of other topics.